First off, welcome. This is the Republic of Work Lunch and Learn series. I'm Shane Costello. I'm a solicitor at Holmes and Malley Section. We're just down the road from Republic of Work, 1A South Mall Cork, and we've offices in London, Dublin, and Limerick as well. So national spread and also into the UK. We've also got access to international firms in 60 countries, part of the International Lawyers Network. So quite a large global spread of corporate lawyers, specializing mostly advising companies. And that actually is my speciality myself on the employment side of things. I would be a corporate employment advisor, not really taking individual employment claims. So I suppose what I'm trying to do is impart some knowledge about my experience with working with companies, but more specifically modern growing companies. So maybe early stage or a couple of years old. I felt that was probably the most appropriate for public work. And what we might touch on then is a couple of different topics that's come up recently for for queries from clients or issues that we've just seen that have become problematic in the past due to law change or just by the nature of work changing. So I'll go through the slides one by one. A very quick announcement, I suppose, in terms of the Republic of Work stuff. So these Lunch and Learn series, the webinars, are every Tuesday at 1 p.m. in a webinar format. There are a variety of topics which all businesses can learn from, and you can find the upcoming events on the What's On section of the Republic of Work website. That's republicofwork.com. So yeah, so I might kick off. First of all, thanks very much for joining us, and hopefully it'll be a bit informative. Anyway, your issues that come up with that. Yeah, so I've done the background and the housekeeping. Our firm, I said, we've offices in London, Dublin, Cork, and London, Limerick, Dublin, Cork, and London. On a range of corporate practice areas. We're the employment law unit. I'm the head of the unit in Cork and Limerick. We act for employers exclusively from startups all the way up to listed companies. So we get a wide variety of queries coming in, to do with the basics of employment law, right up to very obscure or kind of specialist queries in relation to pay and annual leave and things like that. So that's where our advisory team comes in. They advise on contracts and policies. And then there's a litigation aspect as well, of course, to employment law, which is the WRC and the Labour Court. Not a place you want to end up necessarily. Some people might have been there in old roles or even in current roles, and it's a part of life. It's one of those things that businesses have to go through and confront, and nobody wants to be there, and we'll touch on that a bit later. But look, it is part of the services we offer. My team my unit is part of the broader corporate and commercial group. So we've a very strong speciality in corporate transactions, that's M&A work, mergers and acquisitions, investments. So right away from the small Enterprise Ireland, CSF fund, HPSU, up to venture capital, angel network. We can we have advised and do advise on all aspects of investment. So and then obviously there's different teams feeding into that, from our intellectual property team, data protection, commercial contracts team, and stuff like that. So we've got the broad scale of service offering, but today we're going to look at some employment law issues, and as I said, that's my area of specialty. So just to go through, I suppose, the agenda for the presentation, I picked these particular topics because I suppose it's one of the ones, maybe like, for example, HR policies and procedures is something that people can often take for granted, that it's not that important, but it actually forms the basis of a huge amount of employment law claims, queries, issues. And by having HR policies and procedures well drafted and written in a very clear manner, it can stop a lot of those problems right at the outset. The gig economy then is obviously a relatively recent term. It's probably around for the last 4 or 5 years in terms of the terminology, but the actual contractors versus employees issue has been around for donkeys. So it's come to the fore mostly recently because of the modern way that we're working, that people might necessarily have a career for life. It's more likely that you jump from career to career, and even more likely these days that you'll be a contractor, maybe work for a year for a particular company and move on in that space, or even to a new industry and have short-term contracts with many companies. So we'll touch on that. It's a key issue that's arisen, and it also comes up a lot in our due diligence transaction work. And I'll give you some examples of that. And the final kind of bonus topic then really is COVID-19 obligations for employers. Look, we're all sick of hearing about it. We're weary from dealing with COVID and hearing about COVID, but I just wanted to touch on it because it is so important. And we haven't yet seen I suppose, the flush through of claims that might arise because of COVID. So, like they're bound to happen. For example, in the meat plants, we don't even know where it's going to go in terms of those employees making claims against their employer and whether the employer will actually be liable or not. So I'd just like to touch on some of the theoretical points behind your, I suppose, your obligations to your employees, or if you're, a small company, whether you do need to actually enforce or have any policy at all. And the answer is yes, but we'll look at that a bit later. So as I said there, like, we're going to look at the why, when, who, and how of these topics, and we feel that they're really important for early growth stage companies. Get that process in place now, get policies in place now, know whether you're using contractors or employees, so it saves you for future issues that might arise. And I'll try and bring it back to a key aspect of why your paperwork should be in order, which is always that on an exit, a company will be a due diligence will take place on an investment or a sale process, and that's where companies' paperwork and when they look under the bonnet, the lawyer looks under the bonnet of the investor, you need it to be perfect so that no issues can arise. And we'll talk about that a bit over the course of the presentation. So, HR policies and procedures, why are they important? So you can see there the first 4 bullet points. So they set a standard of conduct, their fair treatment of employees, it's for discharging legal obligations, and it's also for consistent application of procedures. What do those mean? So to set a standard of conduct, that means that obviously where you have a culture of being very treating your employees very well, but having it written down in black and white, and this is how we deal with our people. Like an employee handbook is probably key to that. So when I say HR policies and procedures, by the way, I mean the handbook and also the contract of employment, because I suppose both interplay with each other, and they do have kind of both have key roles in the policies and procedures umbrella term. The fair treatment of employees, that is obviously a massive issue for larger employers. Mostly when you see the American companies come to Ireland, the amount of benefits that they provide employees is amazing, but also it's about fair treatment. It's about having those policies and procedures in place where someone can take leave, can take a duvet day, as they call it. There's these kind of aspects of how you can kind of, I suppose, bring different benefits to employment that not necessarily, to do with pay or actual earnings remuneration, but more so the way that you treat your employee. And a HR policy or procedure can help that. So we'll touch on a sample of what an employee handbook looks like a bit later. And you'll see in there that even at the basic level, a lot of the stuff around there is about fair treatment of employees. You've also got a legal obligation to treat your employees fairly, and that doesn't come up until you're actually in the WRC or in a court when you've received a claim. There's no statutory obligation to treat your employees fairly, but what the employees do have is they have a right to fair procedures and natural justice under the Constitution. Now, getting a bit technical here, but it does exist without you ever having to engage with it at the outset of opening a business or having an employee. So really, it's having this handbook has got like loads of benefits for having a handbook and having written contracts. Has loads of benefits for companies. Something that people can maybe just pass over and say, look, not an issue for us. We're a modern business. We work with really great people. We don't need to tell them how we want to treat them, but it actually does have a lot of impact on how people, how they conduct themselves, but also how they feel vis-a-vis their employer. the final point, consistent application of procedures, that is really key, right? So you might have heard the term custom practice. It's often used in employment law, and the reason is because if you treat one particular employee in one manner, and then you treat the next person in the same set of circumstances differently, that always leads to an issue, right? That person mightn't bring it up now, but they might have a grievance that they raise later. They might use it in a claim later on. It's something that has to be very carefully managed. And the way to manage that is by way of having a clear policy and a clear procedure. So if you have it in black and white in your handbook, for example, a disciplinary policy, which is, by the way, a legal obligation under the Unfair Dismissals Act, you have to share that with your employees, and we'll touch that in a second. But the consistent application of that procedure, so that no one feels like they're being, I suppose, ostracized or being held out from the crowd or being treated poorly, right? And that goes back to the fair treatment of employees as well. So consistent application procedures is very easy to manage when you have a very clear policy that all employees are aware of. Now, why are they important? And I suppose that's where the arrow comes in. The issues that might arise if you don't have policies and procedures that are very clear. So when I say price shift, that's a term that comes from transaction work, M&A work. When a buyer comes along to look at your company and they've asked you to do a due diligence process, they've given you a questionnaire that says, please fill out this information about your company. And that information contains, questions around employees. What if it comes back and says, well, we've no HR handbook in place, we've no employee handbook in place at all, we've no policies and procedures in place either. We've had 5 claims in the last couple of years, and we've lost them all because we've actually had no policies in place. I mean, immediately this is, what we say is a red flag to the buyer, where they can effectively say, well, look, number one, I've no interest in buying a company where I have all these issues that I'm going to step into. Because don't forget, if a buyer buys the shares in a company, the entire capital of a company, it therefore then owns all the liabilities too, right? So the employment claims are those liabilities and make up part of it. They're certainly an area that we often see as price shift. So it reduces the price down for sellers. And it's one of those things, if you can get the policies in place at the start and you demonstrate that over years and years of running your business, you've carefully managed your paperwork, it's certainly an attractive proposition for a buyer or an investor when it comes time for them to enter the company. The second one, promoter time, really means the actual management time. I'm sure a lot of you will have been aware of, or been involved in situations where you have, like I suppose, management having to get involved in employee claims, in GDPR claims, in matters of grievances. If you don't have a clear policy, it's very difficult to try and dip in and out of those situations regularly and try and apply a consistent process and procedure. When you have the HR policy, you can say, look, there's your policy. Can you please go and follow that with our HR director or with their HR consultant, whoever. So it is, and we know this from experience, that it is one of those things that bogs management down all the time, staying and then dragging them away from the key aspects of their business, of course, business development and selling. And then finally, objective. It means to treat people objectively. So that's just consistent application of procedures. Again, you have to be. It's a key aspect of employment law. Being objective, not treating people in any way, shape, or form differently unless you've got a legitimate reason to do so. And that kind of touches on employment law as well. Next slide then. So I mean, this was it's the when the HR policies and procedures. Timing is very relevant. You might say, oh, look, we'll do the handbook at a later date. We can't afford to pay the consultant or the solicitor to do it now. I mean, look, that happens. And I wouldn't necessarily say that it's one of the first documents that someone starts writing the minute they open their business. But within the first 12 months, or at least until you start generating kind of numbers of employees, you must put a handbook in place. It has to happen because of the knock-on consequences if you don't have one. Employment contracts in advance always advisable. Basically, look, we have situations where people don't have employment contracts. Come back years, lots of people didn't have employment contracts. The law says that you have to provide an employee with minimum terms within 5 days under the Miscellaneous Provisions Act 2018. You have to provide them with your name, your address, the way that you're going to get paid, a few other details. Within 2 months, you have to provide them with a whole raft of information, which I'm just going to quickly run through. So it's the name, address of the employer, your place of work, the job title, date of commencement, whether the contract is temporary, fixed term, the rate of pay, whether it's weekly, monthly, otherwise, terms and conditions, like hours paid, and capacity. It goes on and on. Right? So that is a legal obligation. You must provide your employees with that statement of work. Now, a well-drafted employment contract will capture all of those issues in one document. So that is why an employment contract is so key. And you can see there that it should be done within 2 months. The 5 days is purely that small statement saying about the basics of employment. 2 months, the employment contract. Then in the Unfair Dismissals Act, what we have is a 28-day period for you to provide someone with a dismissal procedure. Now, a dismissal procedure is actually a bit of a red herring because you don't often see that type of procedures per se in a handbook. What they might say is there's a disciplinary procedure or a grievance procedure. And the disciplinary procedure might have, your informal warning, written warning, final written warning, dismissal style kind of punishments. And that procedure will also, I suppose, be talking about whether, someone's right to appeal or those kind of, it's not called the dismissal procedure, but what they mean here is that you will tell them how or when they can be dismissed within 28 days of their employment kicking off. So look, it's one of those things that you can capture or tick that box by having a proper disciplinary procedure in place. And we would say that the best way to do that is to have it in a handbook, but at least have a policy or procedure and have that available to give it to your employees. Don't get caught by that 28 day period. The who and how. So obviously come and speak to your solicitor about your drafting your policies and procedures. Alternatively, HR consultants, of course, that's the type of work that they do all the time. We work with HR consultants. I suppose we compete with them in some ways in terms of drafting policies and procedures and things like that. But in terms of the litigation side of it, we'd obviously be more heavily involved in that. But we do obviously, draft contracts, draft handbooks, and have a knowledge bank that's very up to date in that regard. So just saying that we draft, review, amend policies, capture gaps. That happens a lot. Someone comes along and says, "Can you have a look at my handbook?" And often there might be 4 or 5 small bits because they might have gotten a handbook from another colleague or a friend or whatever it was. It might be something just updated in terms of current legislation and new case law. So worth looking at your handbook and your contracts quite regularly. So in terms of common issues, then, look, I suppose it has to be usable. So like you can see there, and it might be a bit difficult to see, but there's a sample index for what we know is the basic advice policies for a company to use. Now you can see the amount of them in there. So the handbook can run to 50 or 60 pages quite easily. That's fine, and it has its value, right? But it has to be easy and to follow and flexible for employees to actually use. And I suppose, look, in all businesses, there's employees at different levels using the same handbooks. You can have someone who's very technical and might be well aware of the issues of HR director or finance director, something like that. And then you might have someone who's never had to engage the handbook before. So don't forget that you have to make the document usable, user-friendly, and accessible. Each workplace is different. You may have received a template from a friend and said, "Look, just use that." It might have very obscure things in there about maybe it's a construction company, and also then you might have someone maybe who's working for a technology company who says, "Well, we travel a lot internationally, so we have an international travel policy." You might never ask for employees travel. Small things like that might just cause confusion or say, "Well, what's my obligation here?" If you have a kind of a keen-eyed employee, you could end up in a situation where you have, just fielding questions unnecessarily after putting all the work into the handbook. Better off making it work for you. We've touched on the fairness and the need to adhere to national justice. That's so. Move closer to the mic. Sorry, thanks Angie for the update. So what I would say is for natural justice, it is a constitutional right of each employee to be the right to natural justice. That means that your policies need to be fair. So you can put really whatever you like in your policy, but the point is that then is it going to be usable if it's not fair? Like no is the answer. If it comes before the WRC, how is it going to be viewed? Like it's going to be something that's going to be very poorly viewed, I'd say. So that's why there's no point putting something into a policy that suits you but doesn't suit your employees. This is supposed to be a working document that has the benefit of creating a culture in the workplace. Consistent application, customer practice, we touched on that. Again, from employee to employee, you cannot apply the policy differently from one person to the next. That will be absolutely murdered in the WRC. And it's very important to stick to your policy. Even if your policy looks like it has a flaw in it, it's important. The WRC has said you must stick to your policies because if you don't, it can bring it outside that custom practice threshold, which they want you to have. They want you to consistently apply to all employees. So one of the big issues with their handbooks actually is that you might go off, do all the work getting it amended, fantastic handbook, beautiful drafting, everything, and then not bringing it to the attention of your employees when it's amended. So it's very important that it is brought to the attention of the employees because it affects their terms of their employment. Now, the terms of their contract of employment are different from the policies in the handbook. What a contract of employment is a contract between two parties. Okay, and that in itself cannot be amended without the bilateral approval of both parties. Both parties need to agree to amend the contract of employment. For a handbook, they can be amended from time to time, but it's just a case of having to bring those amendments to the employee's attention. Otherwise, you'd be very unlikely to be able to rely on it in a WRC issue, and therefore fall foul of the WRC. And another key issue that we come across: conflict between the policies in the same handbook. I mean, look, it can happen for and I'll touch on it in a second, but something like we monitor our employees' email, but then does that conflict with the data protection policy and data protection laws? It has happened. That exact thing has happened quite recently. So you have to be careful between each policy that they don't conflict with each other. In terms of recent experience, just to give you an idea of some, I suppose, anecdotal stuff that's happened recently for us, a disciplinary issue led to a constructive dismissal. Constructive dismissal is where an employee says, I can no longer work for this company and I have to go. I resign, but I'll make a claim because they forced me out. The disciplinary was raised or brought about because the employee had behaved poorly with a manager and was about to be disciplined, but they had no disciplinary policy in place. They did not share one with them. They just decided to kind of punish him on the spot. He brought a claim. He brought a grievance against the company. It wasn't successfully heard because they had no grievance policy. And then he said, look, I can't operate under these circumstances because you've got no policies in place. How can I work in this environment? He was successful in his constructive dismissal case and got a large enough payout. By the way, WRC claims are up to 2 years' salaries. You can see that you don't want to be there too often. It can be quite expensive depending on the level of wage for an employee. Probationary dismissal with a poorly drafted employment contract. Probationary periods, as you probably know, are 6 months long. Generally, they can be extended out to 10 or 11 months. Once someone gets to 12 months, you've got the protection of the Unfair Dismissals Act. But up to that point, you can be dismissed for no reason, but the employer still has to use fair procedures. Okay, so but what happened was the employment contract said that this person was a fixed term employee for 14 months. They had a probationary period for 6, and they said we'll extend your probationary period to 12. And what happened was that they then fell foul of the Unfair Dismissals Act. They tried to get rid of this person without any reason. But once they got to 12 months service with the company, they had the protection of the Unfair Dismissals Act, and therefore they fell foul of a claim. Now, it's just really touching on the point that a poorly drafted employment contract can get you into a spot or bother where you thought you were following the terms of the contract, but when the terms aren't right, very difficult to follow them and be successful in the claim. I touched on the conflict of employee monitoring with CCTV, email, and data policies. So, where an employer monitors data, employees' emails, that is allowed when it's legitimate, when there's legitimate aim for it. But how does that interact with your data protection policy, which should be based on the GDPR and existing laws in Ireland? Drafting of non-compete clauses have caused problems because, and they were included in an employee handbook where someone said that you can't work for a competing employer for 18 months, which is well known at this stage in the case law that that's far too long to restrict someone from working. And that was an issue that came up because of a poorly drafted employee handbook. And then the final one was a right to search, where an employer was had suspicions that someone was actually taking drugs during the working day, and sought to search through their locker at work. What happened was there was no right to search in the actual handbook, and whereas the employee had breached the actual the conduct rules of conduct, and it was a disciplinary issue, when they went to search them without the right to search, and that should be included in your handbook, that caused an issue that basically, caused a bigger loss, or mitigated the loss of the employee in a claim, and it actually brought about an issue, that a secondary claim that came about for the employer. So, look, most of them were successful claims. In successful claims, the problem is that we go back to the price chip and reputational damage. If you're suffering in the WRC over and over and over again, no buyer is going to want to touch you. You're going to have to disclose it at that point to the due diligence, or an investor is going to find that very difficult. And then with reputational damage, of course, I mean, like when you're trying to attract top employees or make sales, you don't want to be necessarily having to deal with employment claims. That's right. Now, the WRC claims are now anonymous claims, so it might be A versus an employer, but still, these things get out. Colleagues, other employees, will know about these situations. So it's very difficult to try and protect yourself when you don't have the proper policies and procedures in place. Okay, so on to our second topic. That's the gig economy. So what does it mean? So in effect, it's the rise of the independent contractor and simultaneous demise of the traditional employee. So, I mean, the generations before ours might have had a career for life, be in the same job for 40, 50 years. That has all changed, right? So why has it changed? Well, I suppose, look, technology, people working remotely, the actual need for people is maybe on a project basis. And people like to be flexible. They want to be able to move around. Like, I mean, it's probably one of the only silver linings of the COVID situation has been the fact that people have learned that working from home is now possible. And even in our industry, which is very, very traditional, as you can see, I'm actually obviously at home at the moment. I don't always have clothes in the background of my office. But we've moved home, and it's become far more open, I suppose, manner of working, and workforce is far more flexible because of it. That's quite obvious, but it's been happening for quite a while, mostly in specific industries around technology and things like that. But traditional industries are starting to catch up. So really, I suppose that is the gig economy. The gig being you move from gig to gig, and what it's done is that had the law have to follow that then and make sure that it protects employees and employers in terms of their actual roles, so that independent contractors can't just be shut out completely, or in effect, if someone is working for a business, should they be deemed an employee when they've been told that they're an independent contractor? They don't necessarily want to be one, but they'd rather be an employee and get those protections. So, look, it's a mismatch of kind of flexibility versus the legislation and the traditional nature of working for someone for your whole career. So, how do we determine if someone is an employee or a contractor? Well, look, it's never about the label that you put in it. You could say, like, well, there are my employees over there, those four people sitting together. these are my contractors sitting over here. But what happens if your contractor is doing the exact same work as the employee over here and also has, you know, the same benefits, has the same circumstances? How can we call one an employee and one a contractor? And like, I suppose, well, why do we need to do that? Well, we need to do it because if someone is an employee, they get the protection of the employment legislation, obviously. The termination of their contract is much difficult, more difficult than termination with an independent contractor. And that might suit some employers and it may not suit others. So the reason that then the courts need to look at why someone is an employer or contractor is for that basis. Do they have access to making a claim against their employer or against the person who's engaged them to do work? So the tests applied by the court are the control test, the entrepreneur test, the mutuality of obligation test, the integration test. Very quickly, control test is kind of what it says in the tin. What do you have control over the employee? And these are linked to the practical factors as well. I'll go on to the second, but do you have control over how and where and when they do their work? The entrepreneur test then is that person in business for their own right? I mean, so you see a lot of contractors start a limited company and they say, look, I'll just do that. It makes it look like I'm in business of my own right. But in actual fact, they are still employees, right? So because of the nature of the way that they deliver their services to the company. The company might tell them how they do their services, where, when, the hours, all that kind of stuff. So they've kind of fallen foul of the control test, but they think they passed the entrepreneur test. And it's a good example of why all tests need to be considered by the court. One is never determinative of the relationship between an employee and employer, or a company and a contractor. The mutuality of obligation means, is there an obligation for an employer to give you work, and is there an obligation for you to do the work? So one of the key aspects of a contractor is that I can refuse to do the work. I mean, I've been contracted in to do it. I've been paid for my work. But if I am being told that is your job and you will do it this way, and you must report from work to work from 9 to 5, and if you're not reporting to work, you must ring us to tell us why you're reporting. And after 3 days, you must. So you can see we're touching on the employee policies and procedures, but that is it. It's the mutuality of obligation, the obligation of the employee to work for their employer. That is one of the key tests in determining if someone is an employee or a contractor, and they refuse to work for them. The integration test then is probably one that's come up for most analysis, and that's because if I'm working under the same roof as an employee, but I'm a contractor, how are they distinguished? If I go over to make a cup of tea with the employee, we look the same from the outside. We act the same in terms of our delivery. I have the same email. But what about then stuff like, it comes up, well, how integrated are they in the company? How key are they in terms of the company's delivery? The more key you are, the more integrated you are, the more likely you will be deemed to be an employee. The integration test actually was also nearly found to, people are falling foul of it because of inviting people to Christmas parties. So like summer barbecues, there was a court case where it said that, like, why would a contractor be invited to a Christmas party? Of course, from a culture point of view, it makes so much sense for someone who's working with you to bring them, say thank you for all your efforts. This is Christmas to celebrate together. But in actual fact, we would discourage contractors from being invited to Christmas parties because it looks like they're far too integrated into the business, into the culture, into the way that the business manages itself. So that's just kind of an interesting one to remember. So the practical factors are then as well, the control, we've talked about that, in business for itself, that's the entrepreneur test. Can someone benefit and make more of a profit from the manner in which they do the work? If they can, that's definitely a contractor. Do they have their own premises and provide their own equipment? Another key aspect of whether they're a contractor or not. The hours of work. So if I can determine when I discharge my obligation to you, obligation is a bad word to use, but if I'm a contractor and I've been asked to fulfill a role on a project, I'll say, well, look, I'll deliver it by the 31st of March. I don't necessarily say I'll be here from 9 to 5 to give it to you. That is more like an employee, and that's one of the determining factors. And then finally, substitution. So if I'm working for my employer, if I'm working for Holmes and Sexton, I can't ask one of my another solicitor to come and just snip into my role and deliver the services for my employer for a day. Um, it may be possible, but the likelihood is that that's not going to be acceptable. So, but whereas a contractor should, in effect or in theory, be able to just find another contractor who's able to come deliver the exact same role, subcontract your role out to them, and they deliver for the company. And that's one of the other tests, key factors that factored into when they're analyzing when the court are analyzing the contractor risk scenario. So, the gig economy, why is it an issue? Well, obviously the pros are the flexibility and the project-based assignment. So if I'm a company and I'm looking to do a short-term 2-month contract with a large bank, for example, and I'm a software development company, it might make a lot of sense for me to say, well, I have this need now for 20 more software developers. If they come in on a short 2-month contract, I don't necessarily want them to be employees because of all the hassle that goes with that and all the potential issues that could arise. So what I'd say is that I'll hire them as contractors. They'll come in on a specific, fixed term, deliver the project, deliver it when they want, just get it done on time. That is the pro for both sides. And the contractor could be delighted with that. They can jump from company to company to company, work from home possibly, charge higher, more fees. But then obviously the con for them is that they don't have the protection of the employment legislation, nor have the protection of, I suppose, their, the kind of uncertainty of contracting work, which is, will something arise? There's no obligation to give me work. Do I have the kind of wherewithal to go out and win work for myself? So look, it's a difference in approach, it's kind of that entrepreneurial spirit versus someone who's happier to be an employee. In terms of the risk for employers, then, so the cons for employers, what if you never wanted an employee? You have to make sure that they're not doing stuff. So that's going back to all your tests. You need to look at the agreement that you've struck with that contractor, and make sure that all of those tests are met, so that the person is not an employee. As we said, you can call it contract for services, contractor agreement, services. You can call it whatever you want. That label will never be enough to demonstrate that someone is an employee or a contractor. It comes down to the practical reality of how the relationship is. Other risks for employers: if you have a load of contractors, you haven't been paying employees PRSI for them. What if they're all then deemed employees? You've got that taxation bill, that's revenue going to come looking. Revenue have been very proactive in this space in the last couple of years, especially in the area of like dentists and doctors, where you have a lot of associates who work as contractors effectively for practices, and they've been trying to chase down employee PRSI where they're in effect employees. They're not actually partners or contractors working in a practice. You lose the flexibility when they are deemed an employee. So you hoped to have loads of contractors because you wanted to dip in and out and take different skill sets. You've now got this raft of employees that you never thought you ever wanted. How do I get rid of them? You're caught by the employment legislation. Very tricky place to be. Employment claims then arise because of being caught by the employment legislation. And the final thing, which you touched on a bit, buyer due diligence. If you have said to a buyer, well, I've got all these contractors, they're not employees, I can get rid of them at any time. It turns out then that they actually are all employees because of the manner that you've been working together. That buyer might say, well, I didn't want to buy a business with 40 employees. That was never my intention because of all the issues that come with employees. So look, it's something you have to remember about the structure of your business, what you're packaging to sell on a transaction day. If you have that work, if the work you do is contractor based, it's really, really key to make sure that they're still contractors for you, after all. So recent experience with gig economy. So we've got a client who's very interesting space, actually very relevant at the moment. They do online exams. They need an exam invigilator to literally come in and work for 3 hours to supervise someone through the laptop doing their exam. That is, they must be a contractor. They need them to be a contractor, because if that person wants to be an employee, claims to be an employee, you've got these like huge numbers of exam invigilators. The company is not really in a position to be able to pay 400 employees, but they need 400 people to be able to access and come in and do contract work on an hourly basis. Um, the classic contractor really is the specialist skills. So, for example, for a law firm, if we wanted to do a strategy renewal, we might bring in someone, we might get consultants to come obviously and do it for us, pay them, outsource it. Or we may ask someone to come in and work for us for 3 months and say, we'd like you to come in and get to know the business really well and then give us a strategy around that. That would be the classic contractor who comes in with specialist skills that are completely different to the normal skills that you might have in-house. So then if you have, so temporary increase in need during subcontract, that was again like the example I said, if you get, if you're a software development firm and you need 20 software developers for a new project, contractors are obviously the best option there rather than employees. A strategy team outsourcing but working in-house, that was actually kind of like the example of the classic contractor where you bring them in, you're actually paying them as outsiders, but you bring them in to work in-house. We've seen that quite recently, and it was a very close call about them being employees, and that would have been absolutely terrible for the business because they had no need for a strategy team. It was a temporary requirement, and if they had been deemed employees, it would have been absolutely detrimental to the business. Transaction DD, again, touched on that. Deemed employees caused major issues that led to price shift. The contractors, the group of them, were deemed employees, and therefore then led to the buyer saying, well, I'm either not going to buy, and this person was retiring from the business that they needed out. I'm either not going to buy, or else you reduce the price to make sure that I capture any potential liability for those employees that can claim against them in the future. That is an absolute nightmare for a seller, and something that you could handle quite easily by making sure that you've got the relationship working well for you at the start. And especially if you've got large numbers of contractors, maybe doing the same job, you can roll out that contract over and over and over again, and knowing that if it's updated from time to time, or solicitor looks at it, make sure that it's still captured by the right legislation, then you have, you can kind of rest easy on that and know that, look, I'm using contractors, but I'm pretty certain that there's no issues rising. And obviously contractors becoming too integrated. Like I said, they're at the Christmas party, they're at every single event. They may as well be looked at as employees. On the outside looking in, they're employees all day and all night. That is an issue that's come up for us. We've had a few queries for that. So very quickly, just to touch on COVID-19, I won't wear you down anymore with this kind of information, but I mean, look, the safe workplace is obviously an ongoing, evolving situation. We had the return to work safely protocol, which was released by the government back in June, and what they said was that you have to have done a risk assessment, have put together a COVID-19 response plan, your pre-return to work form, which is when people might be coming back after suffering from COVID-related illness or COVID, or having been in contact with someone. They have to fill out their return to work form. Staff training, always key, but I mean especially key when you've got this novel issue that arises. And then obviously the things that we hear about all the time: physical distancing, the temperature measurement, contact tracing. You do have to do that in work too. Don't forget. I mean, workplaces, sometimes, and I see it inside in our own office. You come in and you haven't seen your colleagues for a long time. It's very easy just to dip back into the old, hang out at the coffee station. Those days are gone, I'm afraid. I mean, we have to implement those rules, and it's very key that that whole umbrella of the safe workplace is implemented correctly, because, as I said, we haven't seen the flush through of the potential health and safety claims that will come. So the Health and Safety Work Act 2005 says that we have to be provided, employees and employers need to provide a safe place to work for their employees. If you cannot do that because of COVID issues, I mean, we don't know how far that's going to go. Like, we don't even know what kind of medical impact COVID is going to have on people's lives. I mean, those cases could be enormous, like in time. So once you've done what you can to protect in as reasonable fashion as you can, that should be enough to be a defense claim. But I mean, again, hard to say for sure, but that is all you can do. Be reasonable in circumstances. Take whatever steps you can to prevent against it. In terms of policies and procedures, then, we've seen some clients actually adopt an exclusive COVID policy, uh, and that has been, very successful in that it captures all of your safe workplace stuff, but also then talks about, sick leave policy, carers leave, annual leave policies, right? So, or you can update those policies within your handbook. Put an extra paragraph in there that says, if you report with symptoms of COVID, we will pay you your sick leave entitlement, whatever way you decide to plummet yourself so that you have either benefited your employees or also matched up with the need to cut overhead. So some people might say, we typically pay sick leave, but for COVID, we're not going to because, we don't know how long you're going to be at work. Like, that is your choice to make. Sick leave is not an obligation. There's no obligation to pay sick leave in Ireland. So, you've got some leeway there. It just then goes back to the HR policies about how do you set a culture for your employees. Do you want to be the employer who takes things away when someone's in their most need? I suppose many people would say no. Caring leave is a specific one because what if someone is at home with COVID and this person can't report to work accordingly? You have to think those things through. Um, Often, look, many people are not paying care leave obviously because it's where someone's at home. Maybe they can work from home, so there's maybe ways to work around these things. Um, Annual leave, we've had a good few queries like this, and I'll touch on it in a second, but annual leave there can be enforced annual leave. So if you want to try and manage the COVID return to work over the next, it's pretty been a reality since June, and where people were returning to work kind of full time over the last couple of months. You don't necessarily want to everybody to go and take their annual leave in November and December when they've all built it up. Um, so you can actually force an employee to take annual leave so long as you give them 4 weeks notice that, look, this time is when we'd like you to take your leave, we'd like you to take your accrued leave up to this date by this date, right? Um, Layoff, short-term redundancy, some bad words there. I mean, like, we don't want to talk about it too much, but it is reality where we're at. With layoff and short-term, there's probably been plenty of people who suffered that in the last couple of months. The wage subsidy schemes kind of helpful there. Redundancies, we've seen an extension of the wage subsidy scheme to March 31st, 2021. We hope that it will discourage redundancies and the need for redundancies. That the cap money has come down to €203. So look, it could happen that companies just say, look, we cannot afford to maintain the levels of employees that we had before, and that is an unfortunate reality of life and where the economy is at the moment. So, they're the kind of procedures that you probably need to look at if you're doing a COVID-19 assessment of how prepared you are. So, I mean, your risk assessment in terms of health and safety there is on your left hand side, but a general assessment for HR teams is on the right hand. Then some recent experience, pretty touched on these already. Yeah, safe place to work. We've done a lot of that for people. Come in and check their policies and procedures. Have we implemented the return to work safety protocol correctly? Forced annual leave, I touched on that. Redundancies, foreign travel for non-essential work. We have a couple of large international and engineering clients that are looking to send employees to, for example, Holland and Sweden were two of the countries. Sweden obviously is a bit of has bucked the trend in terms of their response to COVID-19. I mean, what happens if you send an engineer to Sweden and they get coronavirus? They've gone there for work reasons. I mean, it's a massive minefield for employers. So we were advising that they shouldn't go, obviously, because it's not essential work, and keeping an eye on the green list then of countries that are available, that's available on the government websites in terms of who can travel. The UK is not on that list. We've had obviously had clients say, can I take in some of my management team from the UK to have a meeting in Ireland? No was the answer, really, unless they self-isolate for 14 days first. So, a lot of queries coming up like that. We've drafted a COVID policy for people. There have unfortunately been pay cuts back in March. A lot of firms were applying pay cuts. Some of them have been reinstated by now. But pay cuts are actually technically not allowable under a contract of employment because it's an amending someone's terms of employment. You have to get their consent to do so. So if an employer comes and asks to cut someone's pay, if they refuse, they actually cannot cut their pay. But the alternative is likely to be that they'll be made redundant because they'll look, if we can't cut your overhead, you're going to have to go. We don't need you anymore. So therefore, often employees will come and say, okay, look, I'm willing to enter into some kind of a pay cut agreement. Probationary dismissal, we talked about that. There's some, like, because of COVID, people have been, been sacked during their probation period, terminated. Sacked is pretty bit of a strong word, but or dismissed during their probation period. And probationary dismissal is a tricky one where fair procedures need to be applied. Are fair procedures possible with COVID-19? Yes, they are. I mean, like, you have to just meet people in a different manner. So fair procedures mean that you interact with your employees to let them know where they've gone wrong, and giving them to speak up and represent what problems they maybe had, or give an excuse as to why they've been entered into those kind of problems. And what I would say is that for fair procedures to be applied in the remote working scenario, it has been done. It's very difficult to do it, and I'll be honest. Like, when you're trying to give someone a disciplinary, punishment over a webcam, it's not fantastic, to be honest. It feels very, it feels difficult to try and get across the issues. And finally, then, training culture, new staff induction. Like, I mean, when you're trying to hire new staff and they can't come into the office, it's extremely hard. I mean, like, how do you let them know that we've got such a fantastic culture in our office? All our colleagues get on so well together. They love going for a drink on a Friday or whatever it is. We go running on a Tuesday at lunchtime. I mean, that's very difficult to now show, to demonstrate, to actually have those events. And it's going to be a challenge for people to try and attract new staff to come work for them when they've never seen or touched the fabric of the culture within their business. So that's a tricky one, and we're trying to work through some of those issues for clients. So that's it. Listen, what I'll do now is I'm going to just click out on my slideshow, or my sharing screen anyway, and I'll open up. I hope the meeting's still on. I'll open up the, sorry, anyone who's got a question, I'm going to have a quick look and see if there is any chat box.
Hi, Shane, it's Clodagh O'Donovan. How are you?
Hi, Clodagh. How are you?
Good, thanks. Thanks, Emil, for that. Really informative. The question I have is around, layoffs, right?
Yeah.
So does the employer, are they obliged to share information as to how they decided that one person is being laid off over another, if we'll say there's 3 people doing the same job?
It kind of comes into the area nearly like a redundancy clause. So you'd be familiar with, like, when you've got the selection criteria for redundancy, and you need to come up with, one of the reasons is one of the 5 reasons set out in the Redundancy Payments Act for redundancy. That you're saying, look, we have to implement these redundancies, and also we've now selected you because of the following reasons, and we created a pool. And so that's some of the detail around redundancy. But we would say that the same procedure should be applied to layoff, but maybe in a less comprehensive manner, right? So you should still go and consider whether there's a pool of employees that are, that could be laid off, right? So, and the pool being, if you've got 15 guys working on a factory floor, they're all doing pretty much the same job. How do you decide who should be laid off? We would say that you should do a kind of a selection process like you do in a redundancy situation. So come up with a selection matrix, pick objective criteria like what's their attendance like, what's their, their usability to the business like. Those kind of headings where it's all objective, not subjective, not saying like, well, John is a terrible employee because he, did X, Y, and Z as a disciplinary issue. More something about maybe pay, which is objective as well. Basically, come up with headings where you can actually fill out a selection matrix and then demonstrate afterwards, if the person challenges the layoff, why they were laid off.
Yeah, so that's kind of it. There's a client that I'm working with at the moment, and one of their staff is kind of querying why they've been laid off and somebody else hasn't. And I'm not sure that they would have gone through a very robust process to identify,
Yeah, it's a tricky one. But, like, I mean, look, it was a layoff in relation to COVID as well.
Yeah.
Yeah. So, like, there would be, I think that there's going to be some leeway from the WRC. If that person makes a claim later on in the line or a grievance, you can say like, look, it was like a situation we'd never found ourselves in before. We took decisions to make sure that the business was protected and that we could actually continue. We may have slipped up one or two places, but hopefully it won't be held against us. You know what I mean? That, it'd be kind of trying to make that argument to this stage where you've been trying to paper over the cracks of the procedure, not things like that.
Okay, okay. Thanks for that.
No problem. Do I have any comments? I don't think so. Look, so my email address is actually on the slides, and the slides will be available, of course. And also, you can access, like, if you want to get in touch with Republic of Work, you can get in touch. They'll pass on your details to me or my details to you. That's actually no problem. What I will say is that it's a pretty good series. So kind of stay in touch, see what's on over the next couple of weeks. If you have any problems at all, any employment issues, give me a shout. Very happy to have a chat. I don't have a stopwatch beside my screen, so we'll have a free chat at the start, and we'll see where it goes after that. But look, very happy to help anyone who needs it. So listen, thanks everybody for your time. Unless anyone has any other questions, they can shout now. Oh, maybe I have something in the chat. No, that was it. Everybody's good. Okay. Listen,
Thanks again.
yeah, thanks very much, guys. Take care.
Bye.
Bye.